As you're probably aware, after trials in either the district court or the superior court, the losing side, in some instances the winning side, can appeal to the appeals court or in some circumstances the Supreme Judicial Court of Massachusetts. Recently, there was a decision rendered by the Appeals Court of Massachusetts, Fyffe versus MBTA, and here is a copy of the pamphlet which includes that decision. Fyffe versus MBTA came down in October of 2014 and may prove to be unsettling for some plaintiffs, for people suing. I view it, however, as kind of an idiosyncratic case that's based upon certain overreaching done by the plaintiff's counsel at trial. And I think if we review a few of the items and things that were done at trial, we have a good sense of what goes into proving a personal injury case, what you can establish evidence on and what you can't, what is relevant and probative and what is not. So at trial against the MBTA, coming from a collision that occurred in 2009 when a number of people were hurt because the driver was texting, there was a decision rendered on behalf of Fyffe, the plaintiff, the person suing, in the amount approximately of $1.2 million. In this case, significantly, liability was stipulated to by the MBTA, and that stipulation was accepted by the plaintiff. Sometimes a plaintiff can say, no, I don't want to stipulate to liability. I'd like the jury to hear, and it's discretionary with the trial judge. But in this instance, there was a stipulation agreed to by both parties that said liability, how the accident happened, is not relevant. Nevertheless, the plaintiff's attorney, in the course of that trial, tried to put in a lot of evidence as to how the accident happened. And again, that was no longer in dispute. And despite his many attempts to do so, the judge would sustain an objection made by the MBTA attorney and give, in some instances, a cautionary instruction to the jury. The appeals court was so offended by this, by the conduct of the plaintiff's counsel, that they set this verdict aside for a number of reasons. They outline at the beginning of the decision 3 mistakes made. The plaintiff arguing facts that were not in evidence. Secondly, concepts of liability despite the party's stipulation that the only triable issues related to damages. And third, the plaintiff's attorney arguing that the jury was the conscience of the community and had a duty in this case to safeguard users of public transportation in the future. I discussed the stipulation and how that effectively precluded the plaintiff from bringing out new information. The facts that were not in evidence, for example, was a last-minute assertion by the plaintiff's doctor that the plaintiff, the woman, was at risk for quadriplegia down the road in the future. However, that was not part of the pretrial discovery, so it was a surprise, and it was conceded by plaintiff's counsel that quadriplegia would not be a risk down the road. Yet that came in. And that is yet another red flag, I believe, to an appeals court. And thirdly, the argument that the jury is the conscience of the community and the safeguard of safety and procedures that the MBTA and other defendants should employ, that is something that goes beyond the scope of a case. A case, personal injury claim of A versus B, should confine itself to the facts of A versus B. And you can rely upon the jury as part of its mission when it deliberates to act like the conscience of the community. But to say it and to implicate other things, such as this lawyer did, that media coverage would be involved in the decision, is to bring in extraneous facts and facts that are potentially inflammatory and run the risk of taking the very worthy money away from the plaintiff. Thank you.